This is Efrem Sewell, your accident warrior. Today I'm going to talk to you about slip and falls. And quite often people might be in a grocery store or in some establishment and they slip on something and they fall. And they wonder if they have a case. And in the state of Texas, they have those slip and fall laws. They are very strict rules that apply to it. And here at our firm, at the Sewell Law Firm, we only take about probably 5% of all the slip and fall cases that come through our door. But of the slip and fall cases that come through our door and that we do accept, we usually are able to get settlements on 90%, almost 100% of them. Well, the reason why we're able to do that is that we know how to tell when it's a good case or that you have a case and when you don't have a case. Well, if you go into a establishment, you have to be what's called an invitee. That means that it's a store that's open and they are inviting customers to come in and do business with them. Well, that owner of that business is required to let you know if there's any hazards around the establishment. And they also have to warn you if there's a hazard. But now the state of Texas now protects that owner because the state of Texas don't want Pee Wee and his friend to go in and Pee Wee throws on something on the floor and his friend slips in it and then tells the establishment that, oh, you owe me for some injuries. So the state of Texas put in certain protections so that people wouldn't be involved in that type of deception and what it really is would be fraud. So the state of Texas says you have to, if it's something that is on the floor, like a liquid or something like that, you have to prove that the owner knew about it or should have known about it. Now, the owner's protection is that you have to show that they have known about it long enough to have either one, put up some warning that it was there, and two, remove the hazard altogether, mopping the floor or doing whatever they have to do to remove that hazard. Well, if you fall in that store and you come up and you fell in some water, well, you're going to have to prove that the owner or the managers there at the time knew that water had been on the floor. And you also have to prove that they knew it was on the floor long enough for them to have either prepared it or warned you that it was on the floor. Those kind of slip and fall cases are extremely difficult to prove because you're never able to find any witnesses that will be able to tell you that, oh, they saw it an hour ago. They went and told management that it was on the floor and they are still around to tell you about it. That almost is never the case. So usually when my clients say they have witnesses, well, they have witnesses that saw them fall, but they have no witnesses that can prove that you have a claim against the establishment because that person can't prove or have any kind of proof that the owners even knew that that water or whatever it was on the floor. Somebody could have just dropped it just a minute before you walked down that aisle. Now, when are the owners almost always responsible? It's under the heading that goes, they should have known. So let's say that water is leaking from their air conditioning unit in the ceiling. Well, they knew or should have known in that situation, and they're going to be responsible if you slipped in some water that was dripping from a air conditioning unit, was dripping from a refrigerator, was coming from any type of machine that's in the particular establishment, because they are supposed to be checking those things on a regular basis. And if the liquid or whatever it is you fell in is coming from one of those items, then you definitely will be compensated for any injuries that resulted from you slipping and falling in the liquid that was coming from one of those items. And finally, when it comes down to those type of cases, you want to find out all the witnesses you can while you're there. And in the first instance, you particularly want to talk to witnesses that may have notified the ownership that that liquid was on the floor and how long it was on the floor by the time you failed. This is Efrem Sewell with the Sewell Law Firm.